Good afternoon. Welcome to our webcast, Trial Tactics and Techniques, a view from both sides of the bench and how to effectively present your case to any audience. Welcome. As you can see, we have a wonderful lineup today of judges and attorneys, and we're very grateful that they could join us for the webcast. I'm going to go ahead and kick it off by introducing our producer of the program and also our moderator, Samantha Ellis. She is an attorney with Ritchie Davies, Johnson and Stovall, and her practice encompasses a variety of civil litigation matters, including wrongful death, products liability, employment, student conduct cases, and contract disputes. And we were really lucky to have her as the CLE chair for the TBA's Young Lawyers Division on the East Division, and also the chair of our Law Office Technology Group. So I'm going to go ahead and let her get started, and thank you all. I emailed all the CLE information, and I will forward that to everybody after the event as well. So go ahead and we'll kick it off. Thank you, Samantha.
Hello and welcome everyone. As you can see, we have a great panel of judges and attorneys. I am going to briefly introduce them. There is so much more to their bios and backgrounds, and longer versions of their bios are included in the materials you are getting. So first we have Judge Chappell. Judge Chappell is the criminal court judge for Division 6. Prior to assuming the bench in 2022, Judge Chappell was in private practice for 29 years. A native of McKenzie, Tennessee, Judge Chappell has made Nashville her home since 1995. She received her BA in psychology from Rhodes College and her JD from the University of Memphis Law School. Judge Chappell holds membership in the Nashville, Tennessee and American Bar Associations, the Tennessee Bar Foundation and Board of Trustees, Harry Phillips Inn of Court Emeritus, Lawyers Association for Women, Tennessee Trial Judges Association, and the National Association of Women Judges. She is a former member of the Metropolitan Board of Zoning Appeals and a mock trial volunteer. Next, we have Judge Gregory Gilbert. Judge Gilbert assumed office on September 1st, 2022. Prior to becoming judge, he served as the chief prosecutor of the Domestic Violence Unit in the office of the Shelby County District Attorney General, 30th Judicial District. During this time, Judge Gilbert was the lead prosecutor on approximately 100 jury trials. Judge Gilbert graduated from the University of Memphis Cecil C. Humphreys School of Law in 1999 and went to the University of Memphis for his undergraduate degree. Next, we have Judge Deborah Stevens. Judge Stevens was appointed as the Circuit Court Judge for Knox County Division 3 by Governor Bill Haslam in March of 2013. Prior to taking the bench, she was a shareholder and for many years served as president of the Knoxville office of Lewis King, now Lewis Thomason. Her practice was primarily in the area of the defense of litigation claims involving products liability, professional liability, and insurance coverage. She has tried more than 100 lawsuits and in federal and state courts across Tennessee and also in Alabama, Arkansas, Georgia, Florida, South Carolina, and Mississippi. She received the TBA President's Award in 2012 in recognition of her work as chair of the task force on women in the profession. For a number of years, she was also in the faculty of the ABA TIP/ABOTA National Trial Academy held at the National Judicial College in Reno, Nevada. Next, we have Judge Cynthia Wyrick. Judge Wyrick is a United States Magistrate Judge for the Eastern District of Tennessee at Greenville. Prior to taking the bench in 2019, Judge Wyrick practiced law for almost 25 years, with civil litigation and municipal law as her primary focus. She is a graduate of the University of Tennessee College of Law and a past president of the Tennessee Bar Association. Finally, we have Attorney Doolin Kelly. Mr. Kelly completed his undergraduate work at Vanderbilt University and Cumberland College of Tennessee and then received his JD from the University of Tennessee in 1970. From 1972 to 1977, Mr. Kelly served as the Assistant District Attorney for Sumner County, Tennessee. Mr. Kelly has tried more than 100 jury trials, including many medical negligence cases. He is currently admitted to practice in the United States District Court for the Middle District of Tennessee and the Fifth and Sixth Circuits for the United States Courts of Appeal. He was invited to become a member of the American Board of Trial Advocates, which is by invitation only. And he also serves as one of the trainers for the Eboda National Trial College. Now I would like to pass to Judge Gilbert to give us a few brief opening remarks.
All right, thank you, Samantha, and thank you, the rest of the panel members. I'm really honored to be part of this panel. A lot of experience, and I'm sure a lot of good advice available. I feel maybe like I'm not worthy. So I do want to tell you all a little about myself. I am the judge of the Shelby County Domestic Violence Court here. It was created in 2009 specifically to handle domestic violence cases. I've been in this unit since 2018 as a prosecutor. Before that time, I began with my law career as assistant district attorney in 1999. Have been here in Shelby County the whole time. My entire career has been public service in the criminal courts. So I guess when I give you advice and talk, you have to, I guess, take it. My perspective is from that lens. And I think about civil cases and defense work, and I think a lot of this translates regardless of who you're in front of. It's all persuasive argument, and hopefully it will all translate. I was asked specifically to sort of maybe contrast when I began in early 2000 trying cases, the difference between then and now. And certainly, again, my perspective as a prosecutor, it has changed dramatically from lots of different perspectives. The defense bar is more aggressive. There's not as collegial an attitude. The appellate courts are certainly not deferential to prosecutors like they once were. We have limits on what we can do and say, what we could do and say. When I was finishing out my career at the DA's office, the discovery rules had tightened up. What should be given, when should it be given, and the amount of information from videos to there's a phone in every case these days that should be dumped and searched. There's GPS mapping, social media. There's tons more information, while at the same time, law enforcement has not expanded, at least here in Shelby County. I think that's a national problem. So the investigation qualities would go down. And as a truth seeker, as a prosecutor, which was my ethical obligation, it became difficult to really prepare cases and feel confident you were seeking the truth. You were afraid there was always a stone left unturned. So things have gotten more difficult. And I think about young attorneys having to present cases these days. The simple mechanics are going to be so much more difficult from a technological standpoint. And that was struggling, preparing a case, getting videos ready, editing videos, turning those videos over and presenting them in a way that can be manageable within a reasonable amount of time for 12 people who come off the street who have no technical advice, just average folks. And so that's what I think about going into the future, now that I'm not trying cases, the difficulties that will be faced. And I think back to when I began, and really what I wanted was someone to tell me, give me a formula, give me a script to try this case. I'm not sure what I'm supposed to do. And I have to tell you that almost 25, 30 years on, I can't produce a script. Probably everyone knows trying a case is like driving a car, right? You can watch someone drive a car, you can read the manuals. You can only do it by getting behind the wheel. And that's sort of the way trying a case is. And hopefully today, we all can give you some useful tips, good advice, hopefully some wisdom to guide you because you're going to be stuck in that trial and you don't know what to do. And you're going to hear those voices of all the people who've tried to train you. What do I do? And hopefully we can help you today come up with some of those answers for those future questions you'll have. And thank you very much for hearing from me.
Now we are going to turn to some questions for our panelists. I believe Jennifer may have already said this, but to our attendees, if you have any questions for any of our panelists, either generally or for a specific panelist, then please just submit them in the chat and we will try and get those answered as well. First, for our panelists, can you tell us a little bit about how you developed your own litigation style? And do you have any suggestions for new attorneys on how they can develop their own?
I'll jump in here and really just follow up on what Judge Gilbert had to say when he talked about how you could watch somebody else do it, but until you're behind the wheel, you really don't know how it's going to feel for you. My advice would be to be yourself, because I think it is so tempting as a new attorney to try to emulate some of the greats that are out there, and there's certainly plenty of those. And it's good to get tips from other lawyers on the technical aspects of trying a case. But I think in terms of style, if you try to be something you're not, that comes through certainly to a judge, but it really, I think, can impact your presentation to a jury. I think they need to see that you are bought into your case. They need to see you as genuine and authentic. And I think if you're trying to be someone else, that's difficult. So I'll throw that out to start.
And I'll add, I started out as a law clerk for the criminal court judges, and that's how I sort of landed. I never wanted to be a trial lawyer when I was in law school, never wanted to be. And then I was clerking for the judges and read lots of transcripts and writing post convictions and responses to things. And you realize quickly what questions need to be asked, what questions weren't asked. When you see the record, every and you realize how you need to present yourself. So if you have an opportunity to look at transcripts, do it.
And I've learned over the years in practice now that less is more. We're in the age now of sound bites and social media. And I think that you need to condense your case, not just to sound bites, but to certainly present less rather than more. I've also developed over the years, after 50 years, that I remember in the beginning that I was probably too aggressive. Oftentimes when you have an opportunity to really browbeat a witness on cross-examination, if you're not careful, the jury's going to feel sorry for the witness and not for the lawyer. So I've become much, much less aggressive. Only when you get a witness, you know it's the time to take him on, then you can do that. But otherwise, I think to be courteous and hospitable and amiable is a way to become more credible and accepting by the jury than I have been, certainly in the beginning.
Judge Chappell or Judge Stevens, any thoughts?
Well, of course, the discussion about being authentic and not trying to replicate really sounded near and dear to my heart, because when I started practicing law, there weren't a whole lot of women trial lawyers. So when I came down to the courthouse to watch people try cases, I was watching a lot of guys who were over 6 feet tall. And when we graduated from law school, we were trying to dress to look like we were male lawyers. I can still remember, I'm looking at Judge Wyrick and thinking, I can remember the first time I wore a red suit to court and how comfortable I felt for the first time in my life. So I do think that, we should not miss any opportunities to come down and sit in the courthouse and watch people, whether they're trying a case or whether you're arguing a motion. I think sometimes sitting in the back of the gallery of the courtroom and seeing some of the preeminent lawyers in town stand from the back and watching their knees shake as they're making their arguments is something that's very soothing, particularly to young lawyers. You know, you shuffle for papers. It doesn't, you know, no trial ever goes like they go on TV. And so I think there's something supportive about coming down and just seeing that it's okay to make mistakes. It's okay to be nervous. I think Samantha, one of the best pieces of advice I got from Bob Ritchie, who was one of the best criminal defense trial lawyers in this state, who said, if you ever walk into a courtroom and you don't have butterflies in your stomach, you need to ask for a continuance because you're not prepared. And I think that's a great piece of advice.
So building on Doolin's reference to the idea of less is more, when you have had a challenging or complicated case, what are some ways you have been able to break down your case in a way that's a little simpler for a jury to understand?
You want me to answer that?
Sure.
You know, it's kind of like breaking a bundle of sticks. You can't break them all at once, so you have to break them one at a time. And you've got to, first of all, I think, simplify the case for the plaintiff, because the defense is going to try to complicate it. And the best way to do it is to try to find a real good story that you can build your case around that will stick with the jury, because they're going to remember stories more than they are anything else. It's always difficult to simplify a complicated case, but you just got to do it. You got to do it in bits, just like I said, concentrate on those bits. And if you got a complicated case, believe it or not, the first 10 seconds of your opening statement are going to be where the juror says, I don't know whether I'm interested in this or not. So you better have that first 10 seconds down pat, and then break it into maybe 10-minute points after that. But you better get their attention quickly and their interest quickly. It's always difficult to do, but still less is better than more.
And if I could jump in, Samantha, I think you know, in the criminal courts, we're more, I guess, you know, assembly line. We have a lot of cases, try fast, the issues are similar. But every once in a while, and more and more, we're getting more and more complex litigation. And one of the last cases I had was an incident that happened here in downtown Memphis. It actually occurred all over Shelby County. A gentleman stole a car, went and shot, killed a couple people at one location, and went to a couple more places, and then drove a car over a police officer. And it was highly complex. And one of the ways that my partner and I were able to really put the case on was we pre-trialed every witness. We interviewed over 100 witnesses, and you got to cut the fluff. If there's any duplicative witnesses or they don't add anything, cut them out. We narrowed it down to about 40 witnesses. We broke it down by crime scene. We had about 5 crime scenes basically, and tried to, in our opening and close, stick with consistent narrative that was chronological. You really have to dumb it down, and don't be afraid to, you know, not put everything on. You don't have to put everything, you know, put the things that really matter, that hit your high points of your case, and then you know, back out and you're done.
I agree with Judge Gilbert. I think it's an absolute mistake to try to cover everything that might be important. And I think if you can distill it down to 2 or 3 real critical issues and prove those well, then you've gone about the best you can, because some lawyers just try to, well, I don't know if the jury might not want to hear about that, but you've got in a complicated case to distill it down to the most important points, or you'll lose them, because they'll get where they just not listening anymore.
You know, one of the things that those comments make me think about is, how do you distill down, how do you come up with how you're going to convey your point part of that takes time and it takes quiet thought and real reflection on your case. And I think if there was one thing that I struggle with and, would preach to my lawyer self, if I could go back to when I was starting out, was when you first take on a case, to give yourself the luxury of some time to really plan out in your mind as best you can at that moment from where you are to the day you try your case. Just what do you need to convey? What do you want to convey? Hit the books. Is there a statute that is involved? What are you going to have to put out there to convince a judge or jury that your client's position is the right one? And then, give yourself a roadmap. And so I think it's so easy to get busy with the tasks of lawyering that sometimes we don't take that time to think the way we should early on. So at least that was a struggle for me.
Samantha, one good way to uncomplicate perhaps a complicated case is sometime right around discovery, if you'll have what we call a concept focus group and present the case to them, they'll tell you what's important and they probably tell you what's not important. Therefore, you can concentrate on those issues rather than trying to cover all the bases.
Can you explain to us a little bit what a concept focus group is?
Well, a concept focus group is one that you, like I said, bring in around discovery and just tell them enough about the case that you want to get them to start asking questions. Well, what about this? Or what about that? Versus a focus group that you'll have after discovery is completed. And let's say could be months before your trial is to occur, but then you are able to present what both sides of the case, which would be different than a concept because they're not given both sides of the case. They're just telling you early on what questions they have about the facts that you presented to them.
Samantha, I can give you a good example of a concept issue. So in a products case, one of the things that we all learn is that, the plaintiff is going to have to prove the product is in substantially the same condition as it was when it left the hands of the manufacturer. So getting ready to try a case in Kentucky, and we're taking the car apart, and the issue was the seat belt. And we start looking at this car, and there's a button on the front panel for the windshield, the rear windshield wiper, but there's no rear windshield wiper on the car. So the more we pull the car apart, we find out that the car has actually been hacked in two. So the front half of the car was a Geo Metro and the back half of the car was a Suzuki Swift. Now, as a defense attorney, I'm looking at it going, okay, well, they are not going to be able to prove that that's in substantially the same condition. So we file a summary judgment. The court denies it, says, well, it's just the seatbelt. It's only in the front of the car. So we did a concept focus group. I'm thinking a jury's going to say, how can the manufacturer be responsible for a car they didn't build? And the jury said, oh, we'd buy that car in a heartbeat. So it very early on became what we thought was the issue was not something that was going to win in the court or win with the jury. So we would have wasted a lot of time and a lot of effort had we not taken some time to think about how is that issue going to sell. And so that's, to me, that's a good example of that concept focus.
No, that's a very helpful example. Turning to perhaps, Judge Chappell.
Yes.
Oh, I apologize. And did you have any comments?
Well, I think that I'll just give you some notes that I've made. And the first thing I would say is I haven't met Doolin Kelly, but I graduated law school with his son, Clint. So I would give high regard to any advice Mr. Kelly had because he managed to have another great lawyer in the family. And I think that says a lot about his own lawyering style. And what I did, I was a solo. for most of my practice. I litigated in state and federal courts, criminal and civil cases, several juries, but I found that I didn't do focus groups all the time, although I had done that. I had done mock juries, but I find just talking about the cases with your friends and your family that are not lawyers, that's the critical part. You've got to talk to regular people like that are going to be on the jury is really the most helpful, and be scrupulous about the facts as they're going to sound in the trial. You will learn a lot from common people how that's going to play. And I would just make the other comment, two other things. First of all, and people have mentioned this, the strategy of your presentation is critical, but not just what you're going to do with each witness, but the order in which those witnesses are going to be presented, because the regular person is looking for a TV show style linear presentation. And I think it's helpful to a jury or a finder of fact, if that's not what you're doing, just explain that in your opening statement. We're going to call this expert first because they live in Kansas, or whatever the reason is. I think, and I know this both from asking juries in private practice and because I'm very interested in what juries are doing. And I've asked them after all of the jury trials I've had just since September. They're trying hard to follow everything that's happening, and they're trying to make sense of it. And any little step that the lawyer can take to make it make sense in the larger context of the case, they appreciate that and they want to hear it. And the last thing I would say, and this goes back on something that Doolin said earlier, is the lawyers that seem to be the most well received by the juries, who again, I'm asking because I'm curious, are the lawyers that are zealous, but zealous doesn't mean aggressive. Zealous just means you know your case and you're not afraid to ask the hard questions, but you ask them in a manner that people aren't really cringing in their seats and feeling sorry for the witness. I mean, so that's a really hard skill as a new lawyer that you have to practice. I mean, you just have to get your sister and practice whatever your cross-examination is going to be. It makes the difference if the first time you're talking is the day of trial, the first time you're saying out loud what you're going to say to the witness, you've really missed an opportunity to do a better job. Practicing that once or twice is key when you can do that. I know that was a lot, but you can go to somebody else now.
No, thank you for those comments. And my next question may tie into some of the comments you all have already made, but you frequently hear about the importance of having a theme during trial. How do you go about picking a theme or developing a theme that doesn't sound generic or cliche?
We ask a focus group oftentimes to give us their opinion about what the theme of the case would be. There's nothing though that's more important. We'll never forget, if it doesn't fit, you must have quit, will we? Because we'll live with that forever. That was just brilliant. So it's something you carry throughout the trial, but I struggle with that a lot, but sometimes a focus group will give you some insight as to what they think the theme might be.
I would encourage some flexibility in that, because I've never had a case that came out exactly the way I thought it was going to. And there's always that one line some witness blurts out, or it says at some point that really focuses everybody's attention on what the real issue is. And so I never had a final theme until that last witness testified and we did the last argument for directed verdict. And so I didn't stick real hard with specific themes. And I guess in criminal cases, it's right and wrong. It can get a little hokey if you try too hard. So, use your evidence and use it in closing as the case develops.
And I would suggest starting with the jury instructions early in your case to figure out and to build your theme around the jury instructions. That's probably the biggest mistake that I see is people come in for their final pretrial conference and they haven't even looked at us jury instructions, and that really can make or break your case. So that's what the jury is going to guide the jury. And so your theme has to tie to the jury instructions so that it makes sense to the jury when they go back and look at those instructions. They're going to be looking for guidance on how to come to the right conclusion. And I think if you can, you don't want to do the boilerplate, the law says you have to find this, you have to find a way to make that part of the story, as Dylan was talking about, in a fashion that a jury is going to expect, more like a TV commentary than a law school class. But start with those jury instructions.
Samantha, I got a question for all the judges. Since I think juries often arrive at verdicts based more on emotion than the law, how many of you think they truly follow the instructions to the law in arriving at their verdict?
Well, I can say
Yeah.
that I have been surprised by, because like Judge Chappell said, I always talk to the jury after a trial. And I have been surprised how much they pay attention to the jury instructions. They're not reading every page of the jury instruction, but if they have a question, they're going back and they're looking, particularly like in medical malpractice cases, they're looking for some guidance. And our jury instructions are not the best source of guidance in a medical malpractice case. We tell them that, the standard of care is whatever an expert told them the standard of care is, and you have competing experts. So, but they've read that language and they've gone back and they oftentimes, when I go back and talk to them, have questions about the language of the jury instructions. So I have been surprised on this end that they actually do pay attention to it. Now, I don't for a moment think that if you could take a trial and try it simultaneously to two different jury panels, and to one jury panel you gave a set of jury instructions and the others you just said, go do the right thing, I'm not sure there'd be a nickel's worth of difference between the ultimate verdicts. But I like I said, I have been surprised how much they pay attention to that.
When I've talked to juries, I've gotten mixed opinions. I've had a jury that was focused on my trial partner's shoes, the different shoes she wore every day. So I was really disheartened to hear that. We got a good verdict. I'm not sure why we arrived at it. So I tend to think that there's a lot of emotion in juries, honestly.
Judge Chappell or Judge Wyrick?
I guess I would say, I'm sorry, Judge Chappell.
No, go ahead.
Well, I was just gonna say, I think juries do try to follow the instructions. They try to follow what they're asked to do, but how successfully they do that and balance the emotion that comes with it may be the question. So I guess sort of with what Judge Stevens said, I think there's a lot of truth to.
Well, I agree. I think, so I'm only as a judge trying criminal cases. And I would say, I think the juries have gotten it right, except once. And in that case, I can sleep at night. But more what I think, it's not just applying the law to the facts that they have. What I'm seeing, and I think everybody this is holding true, is people seem to give less and less credence to just a witness that is not corroborated. If it's really much harder in simply just the well, exactly what I've said, the domestic cases that don't have a witness and there may not be something visible. They want something to see. And in the cases we've had now, so body cam is now required in Davidson County. So cases going forward, we're seeing now the pretrial litigation I'm doing almost has body cam, and it's being used on both sides. And I think that's going to be dramatic in the way it will resolve cases that previously would not have been resolved prior to trial. And so just using that as an example, I'm hearing jurors in selection saying, well, what are we going to see to prove that? They have a harder time just accepting testimony as evidence, in my opinion.
I'd like to talk a little bit about opening statements. What are some of the methods you've either used or you've seen other attorneys used that really made an opening statement more effective and persuasive?
Well, first of all, you got to capture their attention, and I told you need to do that in the first 10 seconds if you can. And then extrapolate on that in the next 10 minutes, but you've got to stimulate their emotion. You got to make them curious. And I think you have to tell a story. And going back to less is more, I think that you can, in most cases, give an opening statement in a half hour rather than an hour and a half. And if we all know what TED Talks are about, and you all know that, perhaps you do, that they're limited to 18 minutes. And they talk about complex subjects, because juries after a while just going to say, they'll start daydreaming and they'll pay less attention to you the longer you go. So I think that you work very hard on condensing your opening statement to somewhere between half hour, maybe 45 minutes. Because I think that the attention span of jurors, particularly today, when, like I say, we're so focused on sound bites and short presentations about anything, that you've got to work very hard to do that. But you gotta make them curious, gotta make them answer, why did this happen? For example, in a medical malpractice case, you may be told, well, this is the rule. For example, why do we count sponges at the end of surgery? That's the rule, but you perhaps want to say, why do we count sponges? Why is that important? Why do we take a player who's had a concussion off the field instead of letting him continue to play? So make them curious to want to know what's coming as well. So those are some of the thoughts I have about opening statements.
But what I tell young prosecutors when they would sit with me was always undersell, over deliver. Keep your opening statement simple. Don't overcommit, and plan on saving all that for closing, or most of it for closing. Give them a good roadmap. But again, undersell and over deliver.
If
Yeah,
you can
I would
find,
say-
oh, sorry, go ahead, Judge
ahead.
Stevens.
Go ahead, Judge Wright.
Oh, I was just going to say, if you can find a way to start empowering the jury from your opening statement to do something, to reach the conclusion you want them to reach at the end of the trial, not just for the benefit of your client, but if you can find a way to show that they can change things, not just for your client and make that right, but they can do something that's greater and more broad than just the particular case. That's always, I think, very beneficial.
I was going to say two things. One is, I don't have the precise name, but Dylan reminded me, talked about TED Talks. There's a TED Talk called, I think it's Death by PowerPoint, talking about how distracting and terrible PowerPoints can be
Yes.
when you're trying to communicate information.
Yes.
And I think that's a good TED Talk for anybody who's thinking about pulling out a PowerPoint in their opening statement. They oftentimes lose that storytelling theme presentation. Technology is great, having photographs or diagrams or medical records that are important, sure, put them up there in front of the jury early and often, but running a PowerPoint that you're just reading is just, you might as well, just be given the jury snooze pills. The second thing is, I think the concept of an opening statement has changed. People seem to think that it is an advantage to turn it into an opening argument and make more arguments about the law than they are about their case. And very rarely does anybody make an objection. But I don't think it helps the jury if you haven't spent the time giving them the roadmap on the front end in a fashion that they understand. The law can come later, but if they don't understand which direction the cars were going in at the time of the accident, it's not very helpful them to know who is legally responsible. So, and then the third thing is, everybody wants to build as much of their case into their voir dire as they possibly can. And then they repeat pretty much the same things in their opening statements. And if there's one thing the juries tell me, it's, did the lawyers think we were stupid? How many times did they have to repeat that to me? So I caution you, I get the strategy, but I caution you to make sure that you're not just on repeat in voir dire openings and closings. Good carryover from each is important, but be cautious about it.
So Judge Gilbert and Judge Stevens, you both use the term roadmap in your answers. Can you explain a little bit more to us what you mean by that, and maybe give a couple quick examples of how you can roadmap your case in an opening?
I mean, the simplest, I mean, chronologically makes the most sense for most folks. I think that's sort of what people, when you're telling a story, that makes the most sense. And it's surprising how many, when you start interviewing witnesses, and people come in and people don't think like that when they're talking. So really organizing people and having your witness prepared to testify, from A to B to C, step at a time, over time. And then, like I noted earlier, if you got a big case with many different scenes and many different locations, try to somehow organize it by location, some way that it makes a logical sense when you're presenting it, that fits along with your narrative and the theme of your case.
And I was kind of old school when I practiced. I was writing things down. I always had those big whiteboards everywhere and would kind of cover a whole wall with them. And start simply with, what is it that you're in? And of course, I was generally coming at it from a defense standpoint. And normally in a products case. So oftentimes the technology was going to be a significant part of her defense, and how you communicate that to a jury effectively on the front end. Fortunately for me, when you're dealing with engineering terms, they didn't always come naturally to me. So I was always going to the experts going, explain it to me again, explain it to me again. Because I know eventually I have to explain it to 12 people. So I think by roadmap, what you mean is, what is it that you're going to try to tell the jury to make them believe in your case? And then you kind of identify what issues are going to support that, and then what your list of witnesses are and who's going to support that. You have to develop that whole roadmap. And then that's what you use to say, okay, in my opening, these are the 3 points that I really want to make so that I can pick up on them in my closing at the end, and the jury will understand how it relates. The same thing's true when you're doing a cross-examination of an expert. Sometimes the best expert examination is the one where you don't ask a question at all. Because if they haven't hurt you, why do you want to talk to them anymore? And so I think if you don't have that roadmap early on already plotted out, you don't know that. Your tendency is to stand up and want to ask every question to every witness. And that's not an effective way to present a trial, I don't think.
So I'd like to talk a little bit about direct examinations. What do you think helps make a direct examination more effective? Judge Chappell, would you like to start?
So to me, and I think I'm learning so much just hearing everybody talk, but I would say that back to what Judge Wyrick said, the overarching idea is you as the lawyer have to think about your case. You really cannot spend enough time determining how you're going to present it. And so your first or several witnesses on direct exam, if you've got that one direct exam, you've got to decide, I think, do you need to call 4 witnesses and ask them exactly the same direct exam? I see this a lot with officers. You know, somebody will put on 4 officers that they're really saying exactly the same thing. I think it's important. You do want to have corroborating information throughout the presentation of your case, but I think it's critical to think about, can any witness deliver something different than these other witnesses, and so that the jury can understand. So to me, the direct exam is really let's say it's the victim is testifying, how you're getting out the narrative of the case. It's got to be practiced. You've got to understand, to me, the words that you're going to use for particular components of your case are important, so that you're going to use the same words for all your cases. You're not repeating, like Judge Stevens said, and I agree that's a problem if you ask exactly the same question all the time, but the concepts we need to be using the same vocabulary. And I think that is in planning, and I think that's the most effective way to do a direct examination.
One thing that I'll mention in terms of effectiveness, I think, is if you've got negative information, if this is your client and you're the plaintiff and there's something bad out there, you've got to talk about it in direct. Don't wait and let the defense be the first one to bring it up. So, you know, you don't want to start with that. You don't want to finish with it, but bury that somewhere in the middle and get that negative information out so that you get to drive the narrative about how it fits in with your case.
Any other comments on that?
I would just say that if you're doing a good direct examination, and sometimes you have worked it and you've prepped it with your witness, to be very careful that you listen to the answers that you're getting, because sometimes it sounds too rehearsed, because when the witness answers a question, they've already answered that question, and now you're asking it again because you didn't pay attention to what they were saying. So, you know, a direct examination should be a conversation between you and the person on the stand, and the jury is the audience listening to that conversation. And so I think you just kind of always have to remember that it should be a conversation. And if you tune out to the answers, you're not really having a conversation.
Let me throw out just one other thing in terms of, because I love what Judge Stevens just said about the conversation. It is very important for your client to feel comfortable in the courtroom in order to have more a conversational style. Make sure that you are taking your client to the courthouse, let them sit where they'll be sitting during the trial, and let them get comfortable. Let them understand where you'll be, where the judge will be, where the jury will be, and practice a little bit in that setting if at all possible. And usually the clerk's office is wonderful about helping arrange that opportunity for you.
Now, there's been a couple mentions of cross-examination already, including that not asking any questions is an option. But what other tips do you have for our attendees on how to effectively conduct a cross-examination, in particular of a difficult witness?
Well, the first thing you want to do is get them, first of all, never ask open-ended questions, because they'll bury you. In other words, you ask them to answer the question yes or no. first thing you want to do is get out as many agreements that you can get from that adverse witness. But please don't answer a question you don't know the answer to. Don't give them an open-ended chance, because they'll go on and on and on. And sometimes you have to just say, Judge, would you ask the witness to answer my question, yes or no? And then the witness can explain all he wants to. But if a difficult witness is going to just go ramble on and on and on with any question you ask, because he's not interested in asking your question. He just wants to tell his side of the story. You've got to control the witness, or the witness will control you.
I would say in cross-examination, particularly like if you're dealing with an expert witness, somebody who is convinced they're smarter than everybody else in the courtroom, and they're going to show you how smart they are, that you really just need to have a couple of bullet points. When I sit down, I want this witness to have agreed with me on these 3 points. And if I get that, I'm happy. And, not try to always be going for zingers. And, it's not TV. That person is not going to crumble at your feet and say, oh, yes, you're right. So, look for a couple of good points that you can make and then get out of it. Now, I will say there's one exception. If you get a witness who is rambling on and on and on, and you're not getting a whole lot of help. Sometimes it's effective to just let them ramble and let them go. And I just will look at the jury and I'll turn back to the witness and say, can you tell me what question you answered? So sometimes you can use it to your advantage if you're listening to what the witness has to say. But I agree with what Dylan said. If you you don't want to let that witness take control, not only of direct examination, which is what they want to do, but also your cross-examination. And that's why listen to see whether they really hurt you, because you may not want to give them an opportunity.
Samantha, one thing I found too, that is oftentimes a weakness with these type of experts, and we're talking about these I know everything experts, and I don't have to, I can just sit back and tell you that this is the way it is. They don't have very good knowledge of the facts. And if you can figure that out real quick, it really does punch holes in their sails. Because I said, now your opinion's only as good as the facts, but you don't know what the facts are. And so you got to be careful, because some of them do know it, but a lot of them do not know them. They're not there they haven't spent the time to really know the facts. And it hurts them when they don't.
One thing I'll throw out is it is sometimes very difficult to keep a professional tone and not get snarky or get frustrated and let that frustration show when you've got a difficult witness that you are conducting cross-examination with. But it is so important that you continue to be the grown-up in the room. And, as Dylan said, sometimes you've got to ask the court for a little help, but just don't give in to that temptation to get down and waller in the mud with them. So
They say when you waller in the mud, only the pig likes it.
Now, I'd like to talk a little bit about closing arguments. What are some techniques either that you've used or you've seen that you really thought that was a really persuasive closing argument? I really liked that. Or if you're on the other side, I really didn't like that. Maybe I'm in trouble now.
I'll jump in, or if somebody else, I'll defer if somebody else jumped in. Real quickly, so with prosecutors, there's been a lot of cases recently in prosecutorial misconduct and prosecutors vouching for witnesses, telling juries that they should believe a witness, and because of the role the prosecutor has, how inappropriate that is. And one technique to sort of, I guess, to get around that is really a way to, is actually much more persuasive, is instead of telling a jury you should believe this witness, use rhetorical questions. Do you think a witness would come in here who's been in this circumstance? It has all this evidence. Do you think that that person is not telling you the truth? Rhetorical questions can be very persuasive. So that's one of the things that I've sort of adapted, that I adapted with the change in the law, and I felt it was actually much more effective and more persuasive.
I think it's a huge mistake in closing arguments to tell the jury what they must do, what they must think. Because you're backing up when you start telling the jury, you should do this, or you should do that, or you should think this. Don't ever make that mistake. And I think it's good to go through the verdict form always, because that's one of the first things they're going to be looking at. Then I think you've got to cover the defense that you know is coming right after you sit down, and try to answer the defense as well.
I think something that is very effective, and a lot of people don't do it, is if you can, and there are criminal cases where it's appropriate, if you've got the prosecutor that stands up, and what typically happens is the prosecutor, the lead, is usually going to stand up and give the law. And then the defense is going to close, and then the second prosecutor is going to bring it home. I mean, and they're going to argue it and hammer it. But if you are careful and your first prosecutor goes and it's dry, you don't have to argue. If the defense waives, that second lawyer doesn't get up and deliver it to the jury, all of those fantastic arguments they have that are going to tie all the proof together. You take that away. That's obviously something you've got to talk to your client very seriously about in a criminal case, of course. But when you see that coming, when you know the other side is just going to do the quote law part in that first opening, you've got to consider hard, especially depending on the kind of case, whether your closing argument is going to win it for you or whether you can stop it right there.
So I think the important thing to do on a closing is to go back to that theme and carry it through to your closing. I used to had a friend that practiced law in South Carolina, and he always kind of teased his three important words in his opening statement, and they never seemed to make any sense. Like, so he might be trying a broken axle case in a products case, and his three words would be dishwasher, pig, and something else. And you had no idea how they would come together. But in his closing, he always came back to those three words, and all of a sudden everything made sense to those three words. And he always kept the jury on the edge of the seat when he tied that together. And so I think, we can't all kind of be as clever as that, but I do think making sure that your theme from your opening is really tied to your closing is really an important feature of it. And I'll close with one example of, I thought not only a good closing, but a good response to a closing. And I've told this story before. So this lawyer, we were defending the case. I had an out-of-town lawyer who was lead counsel. Plaintiff's lawyer had sent a letter to his expert that said, enclosed, please find your $5,000 retainer. We would like the following three opinions. And he outlined them, 1, 2, 3. So of course we had that blown up the size of a barn, and the plaintiffs, and so the defense lawyer argued in his closing that when you put $5,000 in the jukebox, you get whatever song you ask for. The plaintiff's attorney stood up and had one response. Our experts, who were in-house experts, were paid $20,000. And he said, for $20,000, you not only get a song, but you get a dance. And so you need to look for those opportunities to zing whenever you can. Do not miss that opportunity. and to be thinking about what the other side might say that's going to give you a chance to have a good comeback.
Well, I think that was a very good story to end on, but Jennifer, are there any questions from our audience?
I don't have any in the chat. If anybody, we are at the top of the hour, but if anybody has any questions, feel free to go ahead and put them in the chat. Otherwise, we'll conclude our webcast for the day. We'll give people 1 minute. All right. Well, thank you everyone for attending. Thank you to our amazing panelists, as well as Samantha for helping us put this together today. I will be sending again CLE instructions in your email. If anyone has any questions, feel free to contact me, and we are getting some thank yous. So again, thank you everybody for this valuable webcast today.